Clear that screen. Here. Okay. We're in session and cause number 325707 and cause number 325709. Both cases are styled the state of Texas versus Clay Audery III. Let the record reflect that we have present Mr. Clay Audery III, and Mr. Clay Audery III is present with his attorney, Mr. Adam Crawshaw. We also have present, representing the state of Texas, Assistant District Attorney Ray Shearer and Assistant District Attorney Daniel Boyd. The court on May 15 previously heard arguments, well, May 15th, 2021, heard arguments from both the defense as well as the state in the case on the motions that was the motion to quash the complaint and information that was filed in both cases. The court also received additional case and a letter brief supplemental case law on the defendant's motions to quash. The court has read all of the cases that both the state and the defense has filed, and in addition, the court has also read other cases. Now, the court has also previously took judicial notice of the court's file in both cases, and so the court is familiar with the court's file. And based upon applying the law to the facts in this case, and after considering argument from defense counsel and argument from the state, this court is going to deny the defendant's motions to quash in both cases. And let's see. If defense and the state does not have anything else on the court's ruling, the court will proceed to a writ. And I have an application for writ of habeas corpus seeking to remove ignition interlock device.
Yes, sir.
Okay. State. Now, this motion was filed on June 22nd of 2021. State, have you had an opportunity to review state's this motion?
Yes, Your Honor, we have.
Mr.
Yes, sir.
Mr. Crawshaw, would you like to go forward in your writ?
Yes. The arrest in this case took place December 2019. Mr. Audery didn't have installed interlock in September of 2020, so approximately 9 months later. In January of this year, this court at the Zoom hearing asked Mr. Audery to install the ignition interlock device, and it had already been done. That device cost him about $150 a month. Since this arrest, he has got married. He and his wife is expecting their first child in February. And we are asking to remove the ignition interlock device so that we can save him the $150 expense every month. He's had no issues on that device that I'm aware of. He went almost a year without it on with no concern, which is okay. And then once he got it on, once he installed it on his vehicle, he put it, the court made sure it was there after the fact, which is also okay. And so I don't think there's any, I think that's good cause to have it removed. This case stands a very good chance of going on a little bit. It's not going to be resolved next month, in other words. We have at least one other live pleading. We have another motion for discovery on file that Mr. Shears agreed to regarding the breath test records in this case. I don't see any reason for Mr. Audrey to have the ignition interlock device in his vehicle anymore, any longer than what he's already had it in his vehicle.
Okay.
That's all.
Yeah, okay.
I don't need to, I'm doing this by allocution because the rules of evidence don't apply. So that's the easiest and most expedient. If the court doubts me, I can explain anything else you want.
Okay, no. Mr. Shearer?
Yes, of course, Mr. Audrey was charged with the DWI second, and according to Code of Criminal Procedure, Article 17.441, it does allow the court to require as a pretrial bond condition that they have a interlock, and which is, it's appropriate in this case. State's ready to give citation of cases if the court feels like it's necessary. In this case, the interlock requirement is just simply a matter of following law as far as the condition of bond. The state feels like that this is, since it is a DWI second, that does heighten our concerns as far as the safety to the public. And so the state would ask the court to not remove the interlock device as a matter of public safety.
Okay, Mr. Crawshaw?
Judge, the 17.441, that's exactly right. Under 17.441B, for good cause shown, we can have it removed. I don't think there's a public safety concern in this case because after the arrest, Audrey installed the device on his vehicle almost, 9 months later. The state can't express any concern, express no concern for 9 months, nor did the court. And then once he had it on, the court made sure of it in January when we appeared this year. So I don't think there's a public safety concern. I think his personal circumstances have changed. I think that's good cause, considering we don't know, at least in Texas or in the country, what's going to happen from month to month. I'd rather not see him under this timeline, not every time, not every DWI second case, but under this timeline. I'd rather see that $150 a month go someplace else.
Mr.
No response, Your Honor. I think the court's very aware of the circumstances here, so there's no power.
Okay, now, so into Article 17.441 of the Texas Code of Criminal Procedure, which is titled Conditions Requiring Motor Vehicle Ignition Interlock. It says, except as provided by subsection B, a magistrate shall require on release that a defendant charged with the subsequent offense under section 49.04, 49.05, or 49.06 Penal Code, or an offense under section 49.045 or 49.07 or 49.08 that of that code has installed on the motor vehicle owned by the defendant or on the vehicle most regularly driven by the defendant, a device that use a deep lung breath analysis mechanism to make impractical the operation of a motor vehicle if ethyl alcohol is detected in the breath of the operator, and not operate any motor vehicle unless the vehicle is equipped with the device. And then B, states the magistrate may not require the installation of the device if the magistrate finds that to require the device would be in the best interest of justice. Now, first of all, the court knows it has authority to require as a condition of bond that a interlock device be installed on a vehicle if a person has a what we call a subsequent or DWI second or more. In fact, the court has, this court and County Court of Law number 2 and 3 have standard bond conditions that we give in all cases. And one of the conditions is that a defendant who has been arrested or accused of any subsequent offense listed under section 49.04 or 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the device if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after arrest. Now, I think the court, well, this case was transferred, if I'm not mistaken, from County Court at Law number 3. It initially was a case in County Court at Law number 3, and then it was transferred over. Normally, when individuals are, if they don't get the bond conditions at the jail when they are released, then we give them the bond conditions when they are arraigned. Obviously, I didn't do the arraignment because that case at that time was in County Court at Law number 3. And so when the case was transferred over to this court, and when we looked at the document, noted that it was a DWI second, the court required our standard bond conditions for DWI second that Mr. Auditor get a interlock device. Now, and the reason why when we look at bond conditions, we also have to consider 17.15 of the Texas Code of Criminal Procedure and its rules for fixing bail. I guess the rules, you have rules for fixing the amount of bail. And one of the grounds, one of the rules is that the future safety, well, let's see, yeah, the future safety of the victim of the last offense and the community shall be considered. And so when we consider whether or not it would be in the best interest, we consider the safety of the community. Obviously, this is not Mr. Altri's first DWI, it's his second DWI. And so as a condition, I think it's in the best interest to have someone who has had a previous DWI to be required to have an interlock device on his vehicle for the safety of the community. Obviously, you may have individuals who may have one DWI and then they may not have another one for a while, and but the fact remains that it's the safety of the community that is of utmost importance and concern when we look at why we require an interlock device on a vehicle. I understand that if a person has some economic reasons for requiring that the interlock be removed, I think the code allows the court. Let's see, I just saw that. Let's see. Oh, here it is. if the judge determined that the defendant is unable to pay for the ignition interlock device, the judge may impose a reasonable payment schedule as provided by, they say subsection F. And that's, I'm reading section, Article 42A 408, use of a ignition interlock device. And so if a person can't pay, the remedy is not to have the person remove the ignition device. The remedy is to set out a pay schedule to allow that individual an opportunity to pay for it. And so the court can do that, but that does not have anything to do with the safety of the community. I think the safety of the community, when we're looking at the best interest, we're looking at the focus here is on the rules for fixing bail that is set out in Article 17.15 of the Texas Code of Criminal Procedures. And so at this time, your motion or your writ is going to be denied. The court believes that would be in the best interest that the interlock device will remain as a condition of his bond.
Judge, the only other matter we have is the order for death test discovery.
Oh, yeah, we're gonna sign that. That's a standard order.
Yes.
Yeah, that will be signed.
I didn't provide the standard order, I provided my order.
So,
Oh.
The state's not opposed to it.
Oh, you're not? Okay. Can I get a copy of that? Hold on, let me see if they put it here. Oh, here it is. Motion to discovery. State you've had opportunity to review
Yes, Your Honor.
this motion. You don't have,
No, it's tracked very similar to our standard order.
okay, let me do this here. I need to, okay, let me do this here. I'm going to compare this to the order that, our standard order that we have. If there, I think there's any issue, what we'll do, we'll call. If not, I'll sign it.
I would like that signed as is, there's no opposition to it, there's no opposition. to my motion.
Yeah, okay, but I mean, want to make sure
There's no
that,
harm in ordering.
who had one? It's on our, isn't it on our website? Our standard order, isn't it on, could you go to our website? I'm gonna let her print it off right quick. They should go to the county's web, county code outlaw number 2, Jefferson County.
Which form are
Is- Let me ask this, is my motion granted?
Well, subject to me reviewing it. I mean, I need to take a look at it. I know he's not opposed to, but I just want to make sure that, it complies with, law and, our, I mean, it's not gonna take, I'm just gonna go ahead and review it. Mhm.
She has it on, which one are we looking for?
You got a standard, go ahead on and print it. It's the discovery, it's the blood discovery order. Crosser, you may be seated.